Good afternoon and welcome to the American Constitution Society's debrief of yesterday's Supreme Court oral arguments in the Texas SB8 cases. If you don't know what those are, you might not be on the right webinar, so you might want to check your Zoom links. I'm Kara Stein. I'm Vice President of Policy and Program at ACS, the country's foremost progressive legal network with more than 200 student and lawyer chapters across the nation. ACS is celebrating its 20th year of shaping legal debate, nurturing the next generation of lawyers, judges, and advocates, and ensuring that the law is a force to improve the lives of all people. We are focusing our work in this anniversary year on our Constitution's founding failures when it comes to race and equality, as well as the need for Supreme Court reform, which we believe is urgent and which relates to the conversation we will have today. If you don't already, we encourage you to follow us on social media and online at acslaw.org. It's now my great pleasure today to introduce our moderator, Kimberly Atkins Stohr. Kim is a senior opinion writer and columnist for Boston Globe Opinion. She is also the inaugural opinion writer and columnist for The Emancipator, a joint independent anti-racist multimedia project from Globe Opinion and the Boston University Center for Anti-Racist Research. She is an MSNBC contributor and co-host with a number of ACS friends of the Politicon podcast, #Sisters-in-Law. Kim will introduce our speakers who will talk with us about how the arguments went yesterday, the possible outcomes, and whether they think the court is and will be responsive to the political moment it is in. Kim, take it away.
Thank you so much, Kara, and thanks to all of you for joining us today. And it is my pleasure to introduce our panelists. Elizabeth Sepper is a professor of law at the University of Texas at Austin. She's a nationally recognized scholar of religious liberty, health law, and equality. And she has written extensively on conscientious refusals to provide reproductive and end-of-life health care, and on conflicts over religion and insurance coverage. And Joseph Tai is an associate dean and professor at the University of Oklahoma College of Law, where he teaches and writes about constitutional law and the Supreme Court. He frequently engages in civil rights litigation and served on the legal team that successfully challenged Oklahoma's same-sex marriage ban a year before the Supreme Court upheld marriage equality nationwide. They both have a much longer list of accolades, which would take the whole hour, but I want to get right into our discussion and talk about yesterday's argument in the cases challenging Texas's abortion ban law, the most restrictive abortion law in the country as we speak. So I want to start with both of you to sort of, on a whole, get your thoughts about how the cases went. Let's first start, in the sake of clarity, let's start with the first case that was argued, which is the challenge that was brought by providers against several state officials in challenging this law. What stood out for each of you in this argument?
So I can start off. I'm actually someone who's often nervous to read the tea leaves. I think the justices are often cagey in their questioning. I didn't feel like that was the dynamic yesterday, especially in the first argument in Whole Woman's Health v. Jackson. And what I noted in particular is that the questions from Justices Barrett and Kavanaugh seemed quite friendly to the claims being made by the abortion providers. And Justice Barrett in particular asked really precise questions, putting together the different provisions of SB8. You could tell that she had spent time really studying the mechanisms and had a lot of concerns about whether, as the state was arguing, abortion providers would actually be able to fully air their constitutional arguments if the Supreme Court forced them to litigate defensively through the state courts. So her questions made me think that I could count to 6, including Justice Kavanaugh, who was much more focused, I think, on the ex parte Young issues, which we'll probably talk about in some detail.
Yeah, and I want to just on that point, Kavanaugh and Barrett, as you said, they were drilling down on how this law works, which I think most of our audience knows, but just to recap, that this law fully puts the enforcement mechanism in the hands of individuals by allowing them, in fact, incentivizing them to bring civil suits against anyone who performs or helps anybody get an abortion. They can seek $10,000 in statutory damages for each act. So these numbers can pile up, and it essentially has effectively shut down the performance of abortions within the state. It's been very effective. And one thing that Justice Kavanaugh said is talking about Ex parte Young, the ability to challenge a law not to allow states to sort of delegate their authority to others. He said, so the question becomes, should we extend the principle of Ex parte Young to, in essence, to close that loophole, saying that Texas essentially opened a loophole. In other words, put aside the language in Ex parte Young for a second, and that is, sorry, I'm skipping ahead. The whole sweep of Ex parte Young would suggest extending that principle here. Joe, what was your takeaway from the comments that Liz pointed out from Justice Barrett and those comments from Justice Kavanaugh?
Well, first of all, I'm smiling because I had that exact passage highlighted from Justice Kavanaugh. And I do agree with Elizabeth that normally reading the tea leaves can be quite perilous because the justices can be a bit cagey and strategic in oral argument. But here they really did seem to wear their concerns on their sleeves, and particularly those that may matter, being in the ideological, being in the middle of the right wing of the court now. That's sort of the ideological middle of the court now. Justice Kavanaugh, I would count in favor of the challengers, the clinics. I would also count Justice Barrett as well. I think she said somewhere explicitly that, Ex parte Young has language that's, I think, strongly in your favor, or language to that effect. I also count Justice Thomas, which was surprising, and maybe you shouldn't bank your retirement on that, but he did say in both cases that the deputizing of these private plaintiffs makes it look like they are private attorney generals. And so perhaps, Ex parte Young can just very easily extend to them without doing much heavy doctrinal lifting. But taking a step back, what was really notable to me about the first case in particular is that it really wasn't about Roe v. Wade. For the swing voters in particular, is about two things. One, the supremacy of federal law, in particular the Supreme Court's role in interpreting and enforcing federal law. And two, about the downstream impact on other constitutional rights that those justices hold nearer and dearer. They mentioned the Second Amendment, they mentioned religious liberty and other rights.
So I want to ask you a follow-up, Joe, on that, and also I want your thoughts, Liz, as well. We're going to talk a little bit more about some of the other rights that these cases could implement and what the justices said about that. But one question that I had coming into this, as the justices took up this procedural issue, this issue that decides whether these cases can move forward to the merits phase, was the fact that in the shadow docket, when the court took this up the first time, they let the law go into effect. So how do you square, Joe, the fact that, as you said, it seems to be a majority in this first case that would allow this case to go forward, at least the one with the providers, with the fact that they still let this law go into effect?
I think there's a couple of things that explain it. One was they acted really in haste in the shadow docket, and that's really a caution against the court deciding things momentously without full briefing and oral arguments. I do think Kavanaugh and Barrett have likely switched their views that the procedural or complexities don't really stand in the way of the challengers being able to vindicate their rights under federal law. But at the same time, what scares me about this case is it's only about whether the challengers can proceed, not whether they can win. And so, that other case from Mississippi is waiting in the wings. And what I worry is that Barrett and Kavanaugh, to the extent that they are worried about public opinion and they were shocked or surprised by the blowback from the refusal to stay SB8, this is a freebie for them. They can allow the clinics to win in this case and then rule against them in the other case. And make it look like they're being, fairly even-handed and neutral.
And Liz, what do you think?
Yeah. So I think that the court taking up the petitions for cert before judgment in both these cases can really only be explained by the politics. I mean, nothing has changed since midnight on September 1st, when the court last issued a shadow docket in that case decision on SB8, except of course the United States entered the fray because of this. But in the whole women's health case, we're basically in the same posture. We have the same level of development of the case. And I think that the justices were obviously very surprised by the pushback. They were surprised that the shadow docket has gotten a lot of attention. And we even saw in a recent appeal involving vaccine mandates and religious exemptions, Justices Barrett and Kavanaugh writing briefly to say, you know what, this just isn't, we shouldn't be using. They won't call it the shadow docket. They want to rename it the emergency docket. And so I think we saw that happening there as well. I want to pick up on another point that Joe made earlier, because I thought I was being quite punchy and possibly counting Justice Thomas as a potential vote in favor of whole women's health. But I thought, he was incredibly skeptical of the response from the Texas Solicitor General that tried to analogize SB8 to a normal tort case, right? The Solicitor General said, look, these people have been injured because their feelings are so hurt by the idea that someone had an abortion. So of course they have standing. It looks like an emotional distress tort. And Thomas he really wasn't having it. So I thought that was quite interesting. Again, I think I have to be a little punchy to count him, but still, it's a possibility and a surprising one.
Yes, please go ahead, Joe.
Oh, just one technical law nerd thing that I realized is that the vote to grant cert before judgment only takes 4, right?
Right.
And so that could possibly explain why they did that and not have anyone switch. But it's clear from the oral argument that at least Kavanaugh and Brett appear to have switched sides.
Yeah, I think that's absolutely right. Now, again, it's always a fool's errand to try to guess anything from an oral argument. I learned that. The last one I got really wrong was the census case from a couple terms ago. Came out totally differently than it seemed. So with that caveat aside, in the US v. Texas case, it seemed that the court had a lot more skepticism toward the Justice Department than it did toward the providers who were the plaintiffs in the whole women's health case. Liz, take us through that.
Yeah, so the United States v. Texas case, of course, is farther advanced than whole women's health's claim. They won an injunction, a very long preliminary injunction decision from Judge Pittman here in Austin in the district court. But I think the court has concerns that have weighed on the United States case the whole time, right? What limits are there on the United States' ability to sue sovereign states for unconstitutional laws, right? If they open the gates here for the United States to sue Texas, will it mean lots of lawsuits by the Department of Justice against states that pass laws that might infringe on constitutional rights instead of allowing normal processes through state or through federal courts? So much of the questioning was about the limits on the United States' standing if the court were to find standing. But I think you're right. We saw a lot of skepticism, including from Chief Justice Roberts, who I think showed his cards that he thought they were requesting an injunction against the whole world and that this power would be totally limitless.
And we heard, again, Justice Barrett even questioning, well, if whole women's health, if the plaintiffs in that case are successful in making a claim that they should move forward, then doesn't that undercut the DOJ's argument that they have to step in here because no one else can. Joe, talk a little bit about that.
Right. So all roads seem to lead back to the Texas case that the providers brought. And it seemed to be the sentiment of several justices, not just Chief Justice Roberts, that, if the providers win in the other case, then it really is unnecessary or kind of moot to decide the standing question involving the United States, which is complex, difficult, and potentially consequential. So I imagine they will probably dodge that bullet if they can. Yeah,
and talk a little bit, just so that we understand, the purpose of the DOJ coming in this case and of allowing people like providers to challenge this law. The purpose is very different. They're really not interchangeable, right, Joe?
Well, the DOJ is arguing that their purpose is to vindicate the supremacy of federal law and defend the coordinate branches of the federal government, including Congress in passing Section 1983 and the Supreme Court interpreting federal law, that no one's going to defend them except for the DOJ. But the Solicitor General did concede that if the providers were able to vindicate federal law, to challenge SB8 in their own lawsuit, that the federal interest would be less weighty. And I forget which justice responded to that skeptically, saying it's not just less weighty, it's just not there anymore.
I want to talk about the ways in which both of these cases could be resolved and when. There are a lot of options before the court in what they could possibly do. Joe, why don't we start with you in the whole women's health case? What are the potential outcomes here?
I think the most likely outcome, whether it's 6-3 or 7-2 or even 5-4, although 6-3 seems to be most likely, is that technically they will vacate the stay from the Fifth Circuit. The Fifth Circuit had stayed the preliminary injunction proceedings in the district court. So once they vacate that Fifth Circuit stay, then the clinics can go back to the district court, can seek a preliminary injunction. In fact, Justice Kavanaugh asked, did you actually also have a TRO requested below? And the challenger said yes. And so I assume that what would happen very quickly is that the clinics would be able to get a TRO in front of the district court if the district court is amenable to their arguments on the merits, and then that would go back up. But I don't think the Supreme Court itself is in a posture currently to issue a stay. And in fact, I think Justice Kagan asked if you would seek some sort of interim relief while this case is remanded, suggesting that they pursue relief both at the Supreme Court and at the district court level.
Yeah, Liz, talk about the potential outcomes here in this first case.
Yeah, I'm really interested as to what Joe just said. This is really central to what happens for people in Texas, right? If the court issues some sort of relief itself, that would mean that abortions can at least plausibly resume in Texas soon. If it goes back to the district court, yeah, sure, maybe they get a TRO, but then it goes back to the Fifth Circuit, and then are we back at the Supreme Court again in a few weeks? And if we are, is the Supreme Court willing this time to issue a stay? They haven't been willing before. And I do wonder, one theme that came up, and actually came up in some of Justice Kavanaugh's questioning, was about the retroactivity of SB8 claims, right? So one of the many strange and unique features of this law is that if an abortion provider performs an abortion while abortion is legal and constitutionally protected in the state, and then the legal ground changes, someone can pursue a claim based on that previous abortion done at a time when it was clearly constitutionally protected. And Justice Kavanaugh seemed really concerned about that. So that did make me wonder, does the Supreme Court want to do something or say something about that? because the danger, and Joe brought up Dobbs, and I'm sure we'll talk more about the Mississippi Dobbs case, right? But there's real concerns both that there's some sort of injunction against SB8, but then SB8 is upheld, let's say, right? Do abortion providers become liable for all the abortions performed in the interim? Now, Whole Woman's Health is brave. Whole Woman's Health has integrity, and they're going to perform abortions, and they will deal with the consequences. But that is not true of all abortion providers in the state of Texas. We have seen some that are showing just total unwillingness to take legal risks and to adopt a more aggressive, I would say, posture. And then the big picture question is, well, what happens if in the Dobbs case, Mississippi wins and Roe is overturned? And then SB8 is fine. Can people sue based on abortions performed when it was legal? It's a very long answer, but it's something that's very much on the mind, I think, of abortion providers here. But I was happy to see that Justice Kavanaugh was thinking about it too.
Yeah, and it's part of what makes this case so complex, even though overall it's pretty simple to see what was being done in Texas. The legal aspects of it are very complex. I just want to remind our audience that I will save some time at the end of the discussion for your questions. If you have a question, please put them in the Q&A in your Zoom window. Don't use the chat function, because then I won't be able to see your question. Please put it in the Q&A, and I will ask as many as I can toward the end of the time. So I do want to talk more about what happens for both of these cases with respect to the Mississippi case, which is being argued next month. But first, I want to sort of hone down on this idea of the way that the Texas law was crafted and the concern that some of the justices expressed about whether other states will be able to craft other laws in the same way to sort of circumvent judicial review when they know that the law impedes on a constitutional right that at least the court has protected. And Elena Kagan, for example, said, I mean, that was something until this law came along, no state dreamed of doing. And essentially, we would be open for business. You're open for business. There's nothing the Supreme Court can do about it. Guns, same-sex marriage, religious rights, whatever you don't like, go ahead. Liz, talk about that concern, the concern of copycat laws from other states, targeting everything from the Second Amendment to the same-sex marriage right.
Yeah, so the Second Amendment seems to have gotten quite a bit of traction, and we've seen gun rights groups filing amicus briefs in the SB8 case because they are concerned that this could be a model used against gun rights and against decisions or future decisions of the Supreme Court that might grant even broader rights to own and bear arms. And it seems quite plausible that it could be a model. And that's why I think back in August, most of us thought that the Supreme Court would in fact block SB8, not because they are particularly sympathetic to the abortion right, but rather because they want to safeguard their own power and prerogatives, and they would need to think about the broader impact on constitutional rights. I'm glad to see them doing it now, but I really would have liked and expected them to do it earlier.
Yeah, Joe, what did you make of that?
Well, you know, I think it was striking that Texas didn't run away from the consequences of its law. There was just a dramatic exchange where Justice Kavanaugh asked, so we can assume that this will be across the board equally applicable as the Firearms Policy Coalition says to all constitutional rights. Answer, yes. And so I think really this case is an opportunity for the court to vindicate its own institutional power, while at the same time leaving the door open to protect rights that it likes, i.e. tomorrow when the Second Amendment case will be argued, and perhaps revisit rights that it doesn't like as much, i.e. next month in Dobbs.
So it certainly seems to be protective of its own power, its own ability to come in and not have state lawmakers be able to write their laws around the Supreme Court. But at the same time, it was very skeptical. It expressed some skepticism, at least, for expanding the role of the DOJ in these aspects. I mean, a lot of us think of the DOJ as enforcing laws to protect rights, such as voting rights. Justice Breyer brought up school desegregation, where the DOJ stepped in. Talk a little bit about that hesitancy that we seem to see from the court in expanding that DOJ right. Liz, you can go first.
Yeah, I think it's a reasonable hesitancy, right? This is an unprecedented law, so maybe it calls for unprecedented relief and unprecedented views of standing. But I think we should all be a little bit concerned, right? I think those who support rights to abortion were excited to see the United States take this role and to win in the district court. But on the other hand, right, administrations change, and you could think if this, if the U.S. has standing anytime a state passes a law that the DOJ thinks infringes on constitutional rights, then we're in trouble, right? We would have seen widespread litigation by the Trump administration, for example, arguing that California had taken property in violation of the takings clause, right? There would have been claims around pandemic measures that affected churches or affected gun shops. And so I think that is just going to be a concern that cuts across ideological lines. I think there's ways to cabin and the United States authority, and this is quite unprecedented. But I think the court's right to be concerned. I don't know. What do you think, Joe?
Yeah, no, I agree. And I counted to more than 5 justices who were skeptical of so-called opening the floodgates for the administration, any administration, to vindicate federal rights in a way that, yes, you could argue it could be cabined in unique situations where states are trying to evade judicial review and flout the supremacy of federal law. But on the other hand, I think there is that very real concern that the DOJ could then just weaponize its ability to go after state laws that it doesn't like, when private enforcement mechanisms or private challenges could just be as successful if the court allows some sort of extension of ex parte Young to this type of unique scheme. And so I just don't see the court in the United States case allowing the US to have standing to go forward.
Can I ask who you count? Who do you think is going to vote against the U.S.?
Oh gosh, I thought Kagan was skeptical. I thought Breyer, counting 4 billion lawsuits and 3 billion of them have constitutional claims. And then you add the usual suspects. I think Roberts, and then add Thomas and Alito and Gorsuch, and you have at least, what is that, 6 already?
I think so.
So I want to go to the Mississippi case. I mean, we're talking about how all of this can turn out. We have the Mississippi case that's being argued on the 1st of December. That is on the merits. That's a straightforward challenge to Roe versus Wade. And there are lots of ways that the court could end up deciding that case that could impact what happens in Texas. They could say nothing about Roe v. Wade and just say that there's no constitutional problem with a 15-week ban, which is what is presented in Mississippi, as opposed to an essential 6-week ban in Texas. It can strike down Roe v. Wade, which would clearly impact both cases, or do something else. I want to start with you, Joe. What could happen there, and how might each of those scenarios affect what happens in Texas? It's really complicated.
It really is, and I think it's especially complicated when you have the right wing of the court which is hostile to Roe v. Wade, but I think not equally ambitious about what to do with it. I think you probably have Alito, Thomas, and Gorsuch willing to overrule Roe v. Wade, but the controlling votes then will go to Barrett, Roberts, and Kavanaugh, and I think they're more concerned about the institutional credibility of the court, and I think they're more cautious in their decision making, even in the face of precedent that they're hostile to. So I think you may end up with a fractured decision in Dobbs that essentially may uphold the Mississippi law, may recalibrate Casey to allow greater state restrictions earlier in the term, but then leave, I think, the constitutionality of SB8 in doubt. So that's how I predict the Mississippi case would go. That'll be messy, and it'll leave the question of Roe v. Wade unresolved.
What do you think, Liz?
I think a decision in favor of Mississippi is overturning of Roe v. Wade. So I don't think that we should be fooled into thinking that the court is doing anything else if it sides with Mississippi. And I would be enormously surprised if it did not side with Mississippi. There is no principled line that can hold the 15-week line. Now, the state of Mississippi had initially run with fetal pain as a justification, but that has dropped out entirely from its arguments now. The arguments are devoted to the reversal of Roe v. Wade. I think there's plenty of things the court may say other than saying it's overturning Roe v. Wade, but I think states will have the signal to proceed, which means I think that SB8 will be fine, maybe, right? In that it'll be fine to ban abortion at 6 weeks. Now, that won't really be the issue in Texas anymore in any case, because Texas has an abortion trigger law that will revert to criminalization if Roe v. Wade is overturned. Now, they would probably need, that's another big picture question, I think, for lots of states. Does the Supreme Court have to say the words, or can a law professor like me simply say that it's clearly an overturning? I don't know for sure, and I'm not sure that we have a clear answer there, but I think we would see a lot of bans go into effect well before 15 weeks.
Yeah, that anticipated one of my next questions, is that a lot of states have these trigger laws that the moment Roe v. Wade is overturned, then abortion is not only becomes unavailable in those states, it becomes criminalized just on that. So and this sort of leads into the next area of our discussion, which is what impacts the court, right? Are they moved by the political nature of what they do, or are they just ruling strictly on the records before them? There's a lot of discussion about, even if there is a vote to overturn Roe v. Wade on this court right now, substantively, might there be a wariness to do it given the political atmosphere to be the court that overturned Roe v. Wade? You have the Chief Justice that is very aware of the court institutionally and in terms of its reputation. Joe, do you think that that's going to make a difference here?
Well, I agree with Elizabeth that the result in the Mississippi case will be effectively an overruling of Roe v. Wade, that Mississippi will likely win. But I do believe that the rhetoric will be a little bit different, at least for the opinion that the Chief Justice would likely write, a plurality opinion, probably, that purports to uphold some shred of Roe v. Wade, while effectively undercutting it. And I think that is because the Chief and perhaps Barrett and Kavanaugh will be sensitive to the court being attacked as a partisan institution. And we've seen that sensitivity expressed by Justices Barrett and Breyer in a number of public fora. And so I do think that will affect the way that the court writes its opinions. But I agree with Elizabeth that the result will be essentially a gutting of Roe v. Wade, if not an outright overruling.
Yeah, I think we're already starting to hear the drumbeat of a media narrative that is being tried out. I kind of hear two versions. The first is that there is a compromise, right? So, yay, providers win SB8, and oh, Mississippi wins in Dobbs. Isn't that a compromise? It's absolutely not a compromise on abortion. It's simply the Supreme Court allocating power to itself in both cases, quite clearly. So I think that's wrong. And a variation on this is that Mississippi is just like Europe, which of course has universal health care, child care, daycare, and also restricts abortion in many countries around 15 weeks or earlier. So there are these sort of attempts to frame what the court will do as a middle way. And I think that it's possible that the court will try to itself frame its decision in that way. I did want to note, since the trigger laws came up and, since we're thinking about SB8 and what it means, right, for a while there, anti-abortion advocates and legislators had really hammered on women's health as the reason behind abortion laws. And that's just dropped out altogether, right? They didn't care about women's health. It was clearly a fig leaf, and now they don't feel like they have to assert any interest in protecting women's health. I mean, SB8 does not have a health or life exception, just an emergency exception, which is undefined. And that's really quite a big shift, because when you think Women's Health, June Medical, that wasn't a long time ago. Those were very much framed as issues of women's health protections in the form of abortion restrictions.
Thinking about other possible outcomes, I suppose a less apocalyptic one, although I don't know how they would draw the line in principle, is to side with Mississippi, but then side against Texas on the merits. And so in other words, 15 weeks, that's okay to restrict, but 6 weeks, not okay.
Yeah, and still leave that very open. On this question about the court responding to what's happening outside the court building, do you think, especially given the fact that the Texas law was initially allowed to go into effect with that shadow docket or emergency docket order, now we had just rocket docket briefing and argument in the case, and a ruling that would likely come soon on that jurisdictional question. Do you think that's the court responding to outside pressure? Liz?
No, me. Yeah, I do. I think it is. I think the court is moving here based on the blowback from their decision not to decide back in September. And I think they are reacting to that and moving more quickly here. They might also be interested. I mean, they're no doubt thinking about the interaction between Dobbs and SB8 as well. So I think there seems to be a desire to get rid of get the SB8 issue out of the way to clear the deck for Dobbs, which doesn't look as draconian as SB8 by comparison.
Sure, and if I can just add, it also gives them, like I said before, just more political breathing room, right? If you have this false equivalence of we decide for the providers in Texas and then we decide for the state in Mississippi, it gives them room to do that.
Yeah. So given that response from the court, what do you think, if any, impact that might have on the ongoing debate right now about Supreme Court reform? I think we see on the President's Commission for Supreme Court Reform that there's very little appetite for expanding the court, but might there be other areas that receive greater attention, like the way that the court takes up cases or the way they handle interim orders on the so-called shadow docket? Joe?
I haven't heard much talk about reforming the way the court handles the shadow docket, but it certainly has suddenly come to the forefront of the public's attention and criticism, which I think is part of the sting that the court has felt, because this emergency docket has been something the court has been used to deciding capital cases and other emergency matters largely out of the public spotlight, and all of a sudden they're being heavily scrutinized. And so I do think that this is an area now that's perhaps easier to reform than the numbers of justices on the court. And so, I think the court is reacting to some extent to the greater public scrutiny and the concern that the court's internal workings might be subject to reform.
Yeah. Liz, what do you think?
I think that's right. And I think we also got some clear signals when the justices were doing various media and speaking tours after that September 1st decision on SB8, They are reading lots of op-eds and the like in magazines and newspapers. Some of them may be secretly on Twitter, and they're seeing, right, the response. And I think we saw that too in the case out of Texas of the prisoner who was denied having his pastor by his side during his execution, right? Instead of deciding that case on the shadow docket as was anticipated, the court took the case and is hearing his case. And that seemed to be a move inspired by backlash to the shadow docket as well.
I don't think there's, I'm sorry.
Go ahead.
I don't think there's broader concern on the court, though, about the other more structural reforms that have been bandied about, like increasing the number of justices, because I think the justices rightly read the political moment as just, if Congress can't pass infrastructure, how can they even think about Supreme Court reform? So I don't think they're concerned about court packing or anything like that.
All right. I want to ask one more question before I get to some of our audience questions that haven't already been answered from our discussions. But is there anything broader we can extrapolate just so far from seeing the interaction among the justices yesterday in this case, or so far this term? So much was made about the fact that this is now a 6-3 conservative court. What is it about the dynamics of this court that you noticed that may have been surprising to you or noteworthy to you that could help our audience understand the court a little better? Liz?
Yeah, so one thing that I really noted was how angry Justices Alito and Gorsuch got at certain points in the argument. I mean, Justice Alito was essentially arguing the case for the state of Texas throughout. But Justice Gorsuch got quite put out with the Solicitor General. And I think it signals that they thought that they had secured justices who would come along to their truly ultra conservative views of the Constitution. And in some places, they definitely will have those votes, right? But I think that Justices Alito and Gorsuch, rather than moderating, have started to go even more rightward and thought that Kavanaugh and Barrett would come along merrily. And we've seen that break down a little bit lately. I don't know that that will stay broken down, but it suggests that things are somewhat more in flux. And it does raise questions as to whether Justices Alito and Gorsuch will take it out on their colleagues in future cases when those colleagues need their votes.
Yeah, maybe it's just the optimist in me, but listening to oral argument and all the concerns that at least 6, if not 7 justices had about the Texas scheme and the evasion of judicial review and the flouting of recognized constitutional rights, even ones that the justices may disfavor. Maybe Texas has poked the bear too hard with SB8 and the fact that Alito, like you said, Elizabeth, and Gorsuch have taken an even sharper turn to the right. Maybe that has the effect, along with SB8, of moving the other justices a little bit more closer to the center and more concerned about protecting the institution of the court than their long-term goals about evolving doctrine where they would like it to go.
I want to get to some of our audience questions that they've submitted throughout this discussion. One, there were a couple questions that asked about the other litigation that's ongoing against the provider, Dr. Braid, who served as a test case. The more traditional route, essentially, as this law, not traditional, but the way that this law was set up, the litigation that is underway in that case. What will happen with that case, and how does that interplay with the 2 cases that the court heard yesterday? Either one of you can jump in.
So Dr. Braid is represented by the Center for Reproductive Rights, who argued the case. They also represent Whole Woman's Health. There have been 3 lawsuits, last I know, filed in the state of Texas in various courts against Dr. Braid. Now, the Center for Reproductive Rights, his lawyers have filed a action known as an interpleader in a district court in Illinois, where one of the SB8 plaintiffs lives. And an interpleader is basically a state statutory cause of action where a defendant can come into court and say, there's multiple competing claims on this pot of money, in this case, this $10,000 abortion bounty, and there's multiple people who want it. You, district court, sort it out. And the beauty of the interpleader, well, there's several beauties. One thing is it may allow Dr. Braid to raise his constitutional claims, right? We still have not been able to do that. We have not seen abortion providers fully able to argue the constitutionality of SB8. The other thing it does is avoid the Fifth Circuit, right? It takes the case out of the Texas state courts. It takes it out of the Fifth Circuit. They're facing a motion to dismiss. I don't know about the likelihood of success. And I will also say that, as of a couple days ago, I had heard that Dr. Braid still has not been served in any of those cases, which actually points to the arguments on SB8 in the courts yesterday, in the Supreme Court yesterday, which pointed to the fact, how do we even get this going, right? How do we get to raise our constitutional claims? We've got to sit around waiting for the right parties to show up and go through all the process, and it could take years. And I think that that's a signal of how hard that is.
Yeah, Joe, that's a point that I wanted to make. The justices, a key point in the cases yesterday was the ability of the plaintiffs who were sued under this law to actually air the constitutional question. If they can't, how else can they be aired? So how do you see this case playing in?
Well, I think that the state cases, even if they can air their claims in defense, they're still going to be in trouble because there's no preclusive effect if they win in the state cases. So they can just be resued again and again and again, like Groundhog's Day, and if the bounty hunters in state court are playing this strategically, they won't appeal their losses. They'll just file another lawsuit somewhere else. And so the way I see this playing out is that actually the federal challenges will probably more likely reach a decision on the merits than the state cases.
Okay. Another question is, does the second Texas case, the DOJ case, have anything to do with sovereign immunity? Joe, do you want to jump in on that?
Well, the United States can always sue another state, and so there's no sovereign immunity bar there. The question really is whether the United States has standing as a sufficiently concrete interest, particularized interest in bringing this suit against the state. Okay.
Another question, we talked about it a little bit, but I think it's worth exploring a little more since there's a question here. Justice Alito raised the retroactive application of a future change in the law. What was he getting at? Elizabeth, I want to just give you a chance to really say that in a way that could, even if there is a stay imposed in this case, that does not mean that suddenly you go back to the state before this law was passed, because it's possible that even during that stay, if abortions are performed, that could give rise to a cause of action if at the end the challengers are not successful. Did I say that right and explain how that works?
Right. Yeah, it's really hard to know what exactly happened. So and abortion providers have already confronted this question when the district court enjoined very briefly, essentially 48 hours, the SB8, because SB8 specifically says, even if SB8 is enjoined, even if a court says that this is unconstitutional, if it comes back into effect, right, if you go up to the Fifth Circuit and the Fifth Circuit disagrees, then any abortions provided in the interim can be the basis for these bounties. I suspect that the federal courts can design relief possibly to avoid that problem, but I'm not sure exactly what it would look like.
Yeah, and I think all this uncertainty will just, the chilling effect, not only for abortion providers, but for anyone who helps women, is still tremendous, even if the clinics win in this case, because of that uncertainty and the possibility of retroactive liability.
So another question, the court in Roe said it could not decide when life begins. If this court holds that it can't, but the states can, wouldn't that overturn Roe without saying so? And what do you think of that as an outcome? Joe, I want to start with you. You pointed out the possibility that the court could essentially say, well, we're not going to say that 15 weeks is too much, but we'll say that 6 weeks effectively. It's another question was, is this a 6-week ban? The ban is, it's a heartbeat bill, which translates to roughly 6 weeks when there is a heart rhythm detected on a monitor. How might they, I think the question gets to, well, how strong is Roe, even if they don't expressly overturn it, if they allow certain laws to go into effect?
Right. I mean, I was predicting that one possibility is that they compromise by allowing Mississippi to win, but ruling against Texas. So 15 weeks versus 6 weeks. I don't see a principled basis for that. So perhaps I'm coming around more to Elizabeth's view that the court might just simply say, you know, we're balancing imponderables, the health and liberty interests of women. Versus the state's interest in, you know, fill in the blank, whatever the state's shifting interest is, and we'll let the states decide. So I think that is a possibility. I would hope that they would at least strike down SB8 and equivalent laws that, you know, that effectively ban abortion at 6 weeks, but I don't see a principled basis to draw that line.
All right.
I just want to add, if it goes back to the states, right, there was a lot of writing in 91 or so from various constitutional law experts when Casey was expected actually to overturn Roe v. Wade. And the questions that scholars were struggling with should raise concerns. There are questions like, well, can Mississippi, if it bans abortion, can it exercise long-arm jurisdiction, right? Can it ban abortions performed on its residents in other states? Can it restrict the travel of its residents to get abortions? And so, you know, sometimes Roe v. Wade is criticized for involving the courts too much in the abortion question. But I'm quite convinced that the court stays involved even if they overturn Roe v. Wade. There's just going to be a whole host of new questions that states create.
Can I ask a question, Elizabeth?
Yeah.
I think we've both been fairly pessimistic, but I think we were too when you brought up 1991, right? Is there any possibility, right? Any possibility that we witness something like Casey, where there's a coalition that preserves the core of Roe and Casey, the Casey balance?
Like Barrett plays Justice O'Connor or something?
Yes. And
No,
Kavanaugh,
I don't think
and
so.
Kavanaugh channels
Kavanaugh's
Kennedy. Yeah.
I don't think so. But, I would be happy to be surprised by this. But.
So I'm going to ask sort of two questions together because I think they sort of get to similar points. One, some have said that the SCOTUS could overturn Roe v. Casey, Obergefell, Lawrence, Griswold, Loving, Brown could be next. Is that hyperbole? And also, what are your thoughts on the legal arguments regarding a woman's right to privacy as well as healthcare autonomy for those cases? I think both of those are getting at these rights that were not expressly stated in the Constitution, but were interpreted as coming out of the Constitution's protections, like the woman's right to privacy. That's the basis of the rulings and things like Loving and Griswold. Do you think that type of reasoning, if Roe is overturned, could also, I would take Obergefell out of that because that was equal protection. That was a more clearly stated law. But do you think that these other rights could be in peril?
The broader privacy and autonomy rights, if I don't think so. I don't think there is the concerted legal campaign or the divided public opinion that would provide sort of the win for the court sails to go beyond Roe v. Wade. So I'm not as concerned.
Liz.
You know, in the religion shadow docket cases, Justices Gorsuch and Alito suggested that rights that, you know, because there were ones involving both religion and abortion access out of Texas, And they noted that they thought that different standards should apply where substantive due process rights not in the Constitution are at stake, and raised a lot of questions about whether those were constitutional rights at all or invented. So I think, it'll depend quite a bit what the court says. I think it's quite plausible to say there's no right to abortion, but we're not going to decide about contraception. But it's a thin thread, hanging that by which contraception and rights against sterilization and lots of other rights that come out of substantive due process. So I do think that these are all quite connected, and certainly those Jonathan Mitchell, who helped write SB8, right? His argument to the Supreme Court in Dobbs is that these are all together, and all substantive due process rights should be dead and gone.
Let's see if I can get through a couple more quick ones. I've heard that fetal personhood is the next frontier in anti-abortion litigation. Would this lead to the end of abortion rights in pro-choice states? Liz, what do you think?
Here I'm more of an optimist, I suppose. I think that's much less likely, right? This is still very fringe as a view that a fetus is a 14th Amendment person with full constitutional rights. Not really clear what that would mean. Even states like Mississippi have rejected referenda on fetal personhood because it creates a lot of problems, right? How do you run the census? Right? If fetuses are persons, you got to count them. There's lots and lots of issues that would arise by recognizing fetuses as full constitutional persons.
Okay, and a question that I am asked a lot, but I think the timing here matters, is when we can expect decisions in both the cases that were argued Monday as well as the Dobbs case that is argued in December. The timing of both of those, just because of their posture, will be very different. But at the same time, we were saying that the Texas case kind of depends in some ways on the Mississippi case. So what do you think happens there?
Well, the safe answer is always right by summer. And in a way, I guess I don't see that the court wanting to rush a decision in both cases. I think the opinions will be long, the decisions will be fractured, and I think the majority in the Mississippi case will probably want that case to lead, because the Texas case will probably end up back on the court's docket. They'll probably set it for argument later this term. If not, if it goes up faster, they might actually combine argument with the Mississippi case, although I don't think they would do that. I think they would want the Mississippi case to go first and be cleanly argued and conferenced. So my prediction is actually the standard prediction. It'll probably be one of the end-of-term decisions.
What do you think, Liz? Because the Texas case is obviously in a different procedural posture. After the ruling in the procedural question, it will go back and work its way back up on the merits. But what might that timing look like?
So I'm going to go with Dobbs by the summer. I think it'll be at the very end. SB8. So they're trying to move quickly. What that means for the Supreme Court, of course, can seem pretty long to the rest of us. So I suspect on the procedural issue, they want to get it out of the way before Dobbs is argued. Some people are predicting a week. I don't know how you can possibly predict with the Supreme Court, but they seem to want to move more quickly, but we're definitely going to get dissents even on the procedural issue.
All right, well, I wish we had more time, but we only have an hour and we've come to an end of it. Thank you so much to both of you for this really enlightening discussion. And I will turn it back over to Kara Stein for closing remarks.
Oh, Kim and Liz and Joe, thank you for that incredibly insightful conversation. Of course, we will all be watching with deep concern, both about the future of our reproductive rights and the future of our court. And I encourage everyone who tuned in today to engage with us. So come to the ACA's website, connect with your local chapter, and we will hope to see all of you again soon. Thank you so much.
Thank you.
Thank you, everyone.